The Railway Timetables Publishing Company, formed in 1866, had articles of association which allowed the directors to issue new shares and allowed them to do so at a discount or a premium or under whatever other terms and conditions the directors thought fit. Relying on this power, the directors issued several thousand additional £5 shares at a discount. In other words, those who took up the shares received a £5 share, but they paid less than £5 to acquire it. The company fell into difficulty and was being wound up. The liquidators looked at the discounted shares and claimed that an issue of discounted shares was not permitted by the relevant statute, and so these should be regarded as £5 shares which had not been fully paid for. They therefore regarded the balance as being a debt due to the company. They wanted to collect that money for distribution to the company's creditors. Welton, one of the shareholders, challenged this decision. The House of Lords unanimously found in favour of the liquidators. Lord Halsbury said, "I think the legislature, in permitting the existence of a company with limited liability, created a machinery which makes it impossible to act otherwise than in pursuance of the provisions of the statute." Lord Macnaghten agreed with this view, stating, "The shareholders had no power to authorise the directors to do on behalf of the company that which the company itself could not authorise them to do. The Articles of Association no doubt empower the directors to issue shares on such terms as they think fit, but that must mean, of course, on such terms as they think fit, consistently with the provision of the Companies Acts. As a result, the liquidators were entitled to call upon the owners of discounted shares to pay the amounts outstanding on their shares, even though Lord Halsbury acknowledged this would be hard for persons who have relied upon that discount to find out that the article which authorised the issue of the shares at a discount was beyond the power of the company. But not the less on that account must one insist that the statute must be obeyed. From this case we learn that while those forming a corporation have a great deal of freedom regarding the constitution of the corporation, the constitution cannot be contrary to the requirements of the corporation's legislation.